Hi everyone, Marcus here from Southern Waters Legal. Today we've been asked by our clients to look at stand down provisions in contracts and what would happen if your business was forced to shut down. Would you be forced to take paid leave or unpaid leave? So first we look at your employment contract. Does it contain a stand down provision? Now, a stand down provision would stipulate circumstances where your employer is entitled to stand you down without pay. If these exist, you'll be governed by them. If they don't, you are then governed by the Fair Work Act. Now, the Fair Work Act states that an employer is entitled to stand down an employee in circumstances where they can't do useful work, and these circumstances are defined as where there's a stoppage of work, which is beyond the reasonable control of the employer, where there's an industrial action, or where there's a breakdown of equipment. Now, a stoppage of work which is beyond the reasonable control of the parties or the employer should be taken on a case-by-case basis and will be contingent on the type of business and whether or not the stoppage can be worked around or whether it definitely needs to be stopped. I would recommend that a employer takes a commercial and pragmatic approach here. So instead of forcing an employee to take unpaid leave, I would be looking to negotiate with them to take, if they have it, annual leave, use their sick leave, use their long service leave, which may be accrued, to avoid any potential employment law issues which may arise out of the recent coronavirus pandemic. So if you have any questions, get in touch with us. That's a very broad brush overview of the employment law issues at hand, but we look forward to hearing from you if you have any questions.